much. So hopefully the next time we will be in person again. For the time being, thank you once again for the kind invitation. I'm going to touch on the same topic of my colleague before, and since the Italian legal system is strongly derivative from the French system, I would like to focus maybe on a few differences compared to what Michael told you a few moments before. In Italy, of course, liquidated damages are recognized and strongly encouraged. Penalties in the sense of private fines are not enforceable, even though there is a slight change in the last few years. The Italian Supreme Court is starting to recognizing that in some particular circumstances, penalties could be enforceable as well. Now, having said that, the main purpose of the liquidated damages in the Italian legal system is to avoid the burden of proof for the damages. We could say that basically liquidated damages are, in terms of damages, a lump sum agreement on the damages. Now we have three main problems in relation to construction projects under the Italian jurisdiction. The first one is that, okay, if you apply liquidated damages and you are, for example, the employer, you apply the liquidated damages, you are exonerated by the burden of proof. So meaning you are not required to prove your damage. But the Italian laws, and namely the Article 1384, provides that the plaintiff or the claimant can claim for additional damages if the parties expressly agreed so in the contract. So the first point that I would like to highlight this afternoon is that liquidated damages are not necessarily the sole remedy. It is by general rule, but the parties are allowed to come to a different agreement. Now, what happens if the employer wants to apply the liquidated damages and claim for additional damages as well? Now, in Italy, we have two different case laws in this respect. One kind of jurisprudence says that if you want to claim additional damages, you are able to do so. Help yourself. You are more than welcome. Another stricter jurisprudence says that if you want to claim additional damages, you cannot apply liquidated damage, and you have to prove the whole amount of damage. So, which of course triggers a number of question marks and strategic decisions, because of course if you believe that you have a very strong case, you might want to go for a claim for the whole amount of damages. But if you think that you are very strong up to a certain level, which is pretty much covered by liquidated damages, and the additional part is not so strong, you might want to still limit your claim to the liquidated damages amount. So this is the first point that I wanted to make. The second one is that, as Michael said, in Italy too, we do not have a clear limit for liquidated damages. Parties are free to agree on whatever amount they like. Italian courts, however, are entitled to reduce the amount if it's too high, as in France. In Italy, however, there is a key point to keep in mind, which is, okay, what does it mean too high? We do not have standard forms. Jurisprudence is not so clear. We say that 20% could be fine. It really depends. The key point to keep in mind, however, is that the limit, the reasonable limit of liquidated damages must be established keeping in mind the creditor's interest. So not the amount of the contract, not the financial status of the debtor, but the interest of the creditor, which is in construction projects is of a paramount importance. You can imagine if you are maybe an EPC contractor and you are dealing with a subcontractor and you are negotiating a liquidated damage amount. We all know that the amount of a subcontract will not be nowhere close to the amount of an EPC contract, and the amount of liquidated damages that an EPC contractor is going to pay to its employer in case of delay is going to be very higher than the amounts of liquidated damages that the subcontractor has to pay to the main contractors. Now, according to these Italian principles, the EPC contractor would be entitled to claim an amount of liquidated damages to its subcontractor, which is equal to the liquidated damages paid by to the employer. So you can appreciate the impact of this principle in construction industry, because the proportionality between liquidated damages and the value of the contract is really important and rarely infringed. So there is a strong risk here, at least in Italy. If you are a subcontractor, you might want to be very aware that if you agree on a very high level of liquidated damages, Italian courts will not be able to reduce it if your main contractor will be able to prove that this is the amount that is going to pay to its employer. So this is the second problem. The third one is another thorny issue, is whether let's say the main contractor, as an example, the main contractor is entitled to claim liquidated damages even if no damages are actually suffered. And this is a very thorny issue because you can imagine maybe let's say the civil subcontractor has a tighter program. A delay in the civil works wouldn't necessarily mean a delay on the completion date of the whole works. So maybe the main contractor is not going to pay any liquidated damages for delay to its employer, but nevertheless, the subcontractor would be late and would be liable for liquidated damages. So can the subcontractor claim that no liquidated damages are due because no actual damage is suffered by the main contractor? There is no clear answer, unfortunately. This is a very highly debated matter, and this because the Italian law provisions, which is the Article 1384, as I told you before, simply says that the scope, the goal of the liquidated damages clause is to exonerate the creditor from the burden of proof about the amount of damages. But it doesn't say anything regarding on the fact that the damages are to be actually suffered or not. My personal point of view, my 2 cents, is that the damage must be actually suffered, because otherwise the liquidated damages clause would become a penalty clause. So it would become a private fine inflicted to the debtor simply because is late. And as a penalty clause, it wouldn't be valid. However, there are some scholars but has a different view, saying that even in this case, the liquidated damages clause would be valid because its function would be to make pressure on the debtor to make sure that he complies with the contract. So in construction projects, this is, I think, it's a very interesting point. But in Italy, we still do not have a clear answer. So these are the 3 points that I wanted to make. For the rest, the Italian approach is very, very similar, if not identical, to the French law, because our system derives from the French system, and we still thank Napoleon for the wonderful job that he did back in time. So this is it. I don't want to take up much